Alan. Good to see you. Tell me, just first of all, your overall thoughts so far now that we've seen Lori Vallow Daybell represent herself over the past few weeks.
What I see is somebody play acting to be an attorney. She's learned some legal phrases. She has apparently read some books. She's familiar with having been tried for murder, for several cases of murder. She is familiar with some of the motions that are brought, so she thinks she could just go ahead and bring them herself. The difficulty in this case is that the best defense Lori Daybell has is that she's crazy, but yet she's trying to act like an attorney who knows everything about the law and trying to basically put on this front like, she's a very competent attorney. At the same time, her best defense would be that she's crazy. And people that know her apparently will say that, yeah, she's crazy. But she's kind of thrown that defense out the window because she's raising all these legal arguments that kind of sound good. They don't have any substance to them because she really doesn't know what she's doing. Yeah, we've got a crazy person who is crazy, but at the same time, she has a certain level of intelligence and cunning, if you want to call it that, as well. This is an evil, cunning, crazy, but somewhat, not totally stupid, but foolish.
Do you think she could have gotten away with perhaps bonding to the jury more? Not saying they haven't found her guilty or anything. I'm not saying that, but maybe blaming more on her brother. Or
that's the only.
Go ahead, yeah.
Yeah, this is a conspiracy trial. She didn't pull the trigger. So in a conspiracy trial, the best defense that she's got is to put all the blame on her brother and say, gosh, my brother just is, he was an evil man. He's dead. He's not here to testify, and there's nobody here testifying against me. The brother, maybe he heard me say some awful things about my husband. That I hate him, and my husband's doing awful things to me, and my brother just got the idea. Well, gosh, I will take care of your problem for you, without there being any agreement. In that case, she'd be non-guilty, even if her brother thought he was doing her bidding, by knocking off Charles. But she, that would be the best defense that she's got. Not saying that she has a defense. She's going to the gallows, as far as I'm concerned.
Okay, so a lot of people really wanted her to testify. If you were her attorney, would you have advised her to testify?
Here's the deal with an attorney telling his client to testify. Several things at play here. Number one, if you know your client is going to lie, you are prohibited from allowing your client to testify. They may fire you. But under the rules of ethics, if you know your client is going to lie, you cannot put your client on the stand. All you can do is poke holes in the evidence that the prosecutor, puts before the jury. And I will tell you that the temptation to put a client on the stand knowing that they're going to lie is too much for many, if not most, attorneys. I have seen attorneys put their clients on the stand to tell a fairy tale, even though they know that they're going to tell a fairy tale. I've seen that happen before. It is a very tough thing for an attorney to do. You got to have a lot of fortitude to restrain yourself from putting a client on if you know your client is going to lie. But if I did not think that my client was going to lie, I would want to put my client on the stand. And one of the main reasons, statistics show that in cases where an attorney does not put his client on the stand, 90% of those cases are convictions. So you can figure if your client does not take the stand, your client will be convicted. So what are you going to do?
Interesting. Okay, so she didn't take the stand. She doesn't plan on taking the stand, but she has this weekend to prepare her closing argument if it's not already prepared. We know the closing argument isn't evidence, that the jury's told this isn't evidence, but what type of things can go into a closing argument, and how effective do you want that argument to be?
Oh, it's everything. Several things go into making a closing argument. There's a real art to it. There are seminars and long seminars and classes and everything on how to put together an effective argument. And I was actually able to sit in on a seminar taught by one of the Watergate lawyers. and talking about, putting together effective arguments. A couple of things. You don't want your argument to be longer than 45 minutes. So you might have your audience check that, see just exactly how long are these arguments are being made. The rule of thumb is 45 minutes is about all the jury, wants to hear. If you're going on longer than that, you're wasting the jury's time. Another a key thing in closing arguments, whether it be civil or criminal, is what we call promises kept. And that means that when you start your trial, you have opening statements. And in an opening statement, all you're allowed to say as the attorney is the evidence will show this, the evidence will show that. You can't make an argument, as to weighing evidence or anything like that. All you can tell the jury is what the evidence will show. And at that point, you tell the jury what evidence is going to come out in favor of your side of the case. And in closing argument, that's when the jury wants to know, have you kept your promises? You told us you were going to show this, this, and this. You told us that there was going to be no evidence that there was an actual agreement between Lori and Alex. You told us, these various things. You told us there was going to be, no witness that Lori had actually committed this crime. And they want to, so at closing argument, you want to remind them, okay, that's what we showed. We showed these various things. Another thing about closing arguments, something prosecutors always do. The judge will give the jury instructions on how they're to decide the case. He'll instruct them on the different elements, of the offenses. And they might have 9 different elements that they have to prove. The prosecutor will go over each one of the 9. They'll put a chart, in front of the jury and say, element number 1, this is what we have to prove. We prove that because of this. Element number 2, we prove that, because of this. It was in Idaho. It was in this county. It was, the person did die. The person did die on this date. All these various things that they have to prove. And what the defense attorney will do in response to that, the prosecutor will have, say, maybe 8 of those 9 things are, everybody knows that. 9th will be the key one. The prosecutor, in his argument, will try to get the jury nodding along, saying, oh, yeah, well, I guess if they got 8, they must have all 9. And what the defense attorney does is brings the jury back to, wait a minute, this is not a case about 9 elements. It is a case about 1 element. Was there an agreement between Lori and Alex? That is all you need to be concerned about. And they need to focus on that. And I have actually spoken with jurors, in voir dire, where we're choosing a jury. I've had 114 jury trials. And when you're picking a jury, you can ask the members of the jury what their feelings are about different things. And I had a recent trial when I asked one of the jurors, what if the prosecutor, has 9 things to prove, and, they're 8, or, they've really proved these 8. You're not sure about number 9. What do you think? And I've had, some of them say, well, probably proved all 9. I said, well, wait a minute, it just establishes a fact. They proved 8, and number 9 is, well, maybe yes, maybe no. That's called reasonable doubt. And there are, the prosecutors will try to get the jury to think in that mindset. Okay, we're nodding the head. Yeah, 1 through 8. No, so number 9. Okay, that must be there too. It must follow because 8 are there, 9 must be there too. So the defense attorney needs to bring the jury back and say, this is a case about 1 issue. Did they prove this issue? And then you give all the reasons why, from the evidence, why that is lacking. Because this kind of a trial is all about reasonable doubt. If there is a reasonable doubt, they must acquit. And that's something you have to, that doesn't just start in closing argument. That starts when you're picking the jury. That has to be ingrained in the mind of each one of the jurors that this is all about reasonable doubt. If there is any reasonable doubt, that they must acquit. And that's a hard thing for people to do, especially if you have a heinous crime, that has occurred. It's tough, for jurors to think in terms of reasonable doubt. But for the most part, I think the jurors really try to follow those instructions, as hard as it may be in some cases.
Well, it'll be fascinating if maybe Lori Vallow is somehow watching this. You may have given her a few tips if she prepares those closing arguments. Alan, thank you so much. Is there anything you want to add?
Uh, the only thing I would add is I wouldn't want to touch this defense with a 10-foot pole. I told one of her attorneys earlier that I'm glad that I'm not the attorney on the defense on this case. I like to like my clients. Let me put it that way. I would not be comfortable at all, being the defense attorney on this case, and so for that reason, Lori has spared somebody a lot of pain by doing it herself. And I think one of the questions you had before was why might a person in the defense not call any witnesses?
Right. Oh, yeah. Yeah. Why would that be?
Because they're stupid or they're incompetent. They have no evidence. That is the those are the things that I see in this case. In general, is there a time when you would call on witnesses? It would have to be a case where you were convinced. I mean, it's very risky to do that. It's probably malpractice for a defense lawyer to do that. But the only time you'd even consider it is like if you're convinced that the jury hates the victim, or that the jury hates the main witness, or that the jury hates the prosecutor. I had a case in another county in Idaho about 6 or 7 years ago where we were in the course of picking a jury, and the prosecutor says to me, "I just want 12 people who don't hate me on the jury." He says, "That's all I want." And that was an interesting case. Yeah, my client was acquitted in that case, actually.
Well, I guess when you heard that, you're like, okay, I'll take it, please. Good.